Good afternoon, everyone, and welcome to Subcontracting Smart, Labor Relations and Subcontracting Plan Obligations between Prime Contractors and Subcontractors. I know you guys can't wait to hear the wealth of information we have for you today, but before we do that, I have to tell you that all lawyers in good fashion have a disclaimer, and this is ours. So while we love presenting from you, we are not rendering any specific legal advice, and this stuff can all change very quickly. So please refer to our website for any changes in any applicable law, and if you have any questions, please let us know. My name's Nichole Atallah. I lead our labor and employment practice group here at PilieroMazza, and I'm here with Katie Flood.
I'm an attorney and associate in the government contracts practice group here as well.
And PilieroMazza we're a full-service law firm here in Washington, D.C. We've kind of made ourselves well-known in the government contracting area and have been practicing in that area for over 25 years. Some of you we know really well, and welcome to those who we don't know so well. As we go through the presentation today, you all may have some questions, and we encourage you to send us those questions. You will hopefully everyone has on their webinar screen the questions box, and we will see those as they come in. We do have a lot of information we want to give to you today. So while some of the questions we might be able to get to as we go through the presentation today, others we'll reserve for the end, and hopefully we'll get done in time to answer some of those questions. If by chance we don't, we will get back to you hopefully before the week is out. And again, our contact information is on the slides. Our slides will be available on our website. We also have a YouTube channel and other information on our website that we'd love for you to take advantage of. So please feel free to go out and take a look at that. All right. Well, Katie was nice enough to let me start today. I said, hopefully I won't put you to sleep, and then she can wake you back up. So
with the fascinating ins and outs of subcontracting plan obligations.
Exactly. So we're going to start today with labor relations. And really our goal, as Katie and I were thinking about why we would want to do a webinar on subcontracting smart and thinking outside the confines of subcontracts, it's because a lot of times we get subcontracts in for drafting or reviewing subcontracts, and there's a lot more to think about than what's on the text. And I think sometimes even lawyers get in the habit of looking at the actual text, but we really want to have everyone think about what are really the implications of that text. What obligations do we have coming out of that text, and what do we need to think about possibly incorporating into our standard subcontracts as we go forward. And this would apply for subcontractors as well as prime contractors, because everybody has competing obligations, and there's also a negotiations and business component of this as well, and we don't want to lose sight of that. So on the labor side, there's a lot of stuff to think about. And what I always say to prime contractors or subcontractors dealing with primes is that whether you like it or not, most of the time prime contractors that receive government contracts are on the hook. You guys are the ones that are responsible at the end of the day. So there is a lot of pressure, even when we're talking to subcontractors, to think about all of the obligations the prime has, and we're going to talk about some of those today. The big one is to make sure that the prime flows down all the obligations it has to its subcontractors, or at least the ones that appropriately need to be flowed down. And sometimes you see a lot of these general provisions that say, everything in our prime contract that's applicable to prime is also applicable to subs. But in the labor and employment context, you have to think a little bit beyond that, because there are some obligations that you may not get out of just by doing that general kind of language. You also have to comply with all applicable labor laws, and a lot of labor laws can, in some contexts between primes and subs, make you almost co-employers in certain contexts. And so we have to make sure, or at least have some reasonable amount of certainty, that our primes and our subs are all under the understanding that we have to comply with all of our applicable labor laws. And that's, your Fair Labor Standards Act, if there's Service Contract Act or Davis-Bacon Act, any equal employment opportunity provisions, and that's OFCCP and the EEOC. And so we're going to talk about the implications of some of that as we go along. And most subcontracts have some sort of general warranty that that's going to happen in them. But you want to make sure that that understanding is out there and that both parties have what they need to ensure that they have some comfort level that that's happening. Because as you know, on some government contracts, employees, prime and sub, are sitting next to each other doing the same job. And they're talking about their wages and their fringe benefits. And when they start talking and they figure out that it's different, that's usually when we have a problem. But we need to think about what else. So some of the biggest questions I get are about non-solicitation provisions. Sometimes it's par for the course. And what am I talking about when I talk about a non-solicitation provision? We're talking about basically employee poaching. Many subcontracts have a provision in them that says, either one party or both parties aren't going to solicit or try to take away the other's employees for the term of the contract, and sometimes even for a little bit of time after the contract terminates. But certain contracts also have some competing interests. For example, sometimes prime contractors don't want a non-solicitation provision because they know the reality is that if their customer starts to like a particular subcontractor employee, they may want, and at the same time the prime wants to switch out subcontractors, their hands are tied. That may be good for the subcontractor, not so good for the prime contractor. So you really have to think about what kinds of situations am I possibly going to see during the life of this contract that could implicate my employees. And your employees are a very important and critical asset of your company. They're going to keep you in the game sometimes. So you have to look at, okay, is this one of those contracts where I have key employees that are really important to my performance of this contract and the government wanting to continue to have my company perform the contract? And if it is, you should probably fight pretty hard for that to keep that non-solicitation provision. You also should think about the differences between the non-solicitation provisions in a subcontract versus having an employment contract with those employees. So if you can't get what you want in the subcontract, you might want to think about, do I need some sort of employment contract, a non-compete or a non-solicitation provision with that specific employee? Just because you have one doesn't necessarily mean you don't need to have the other or vice versa, right? So you have to think about what's the appropriate place for that type of clause. The subcontract is only going to protect you with respect to the other company. The employment contract is going to give you some leverage to try to prevent that employee from leaving you. So it's important to think about both aspects. What else do we need to think about? We need to think about going beyond the actual flow-down provision when we're talking about the OFCCP, which is basically all of your equal employment opportunity type stuff, the Service Contract Act, and the Davis-Bacon Act. And why do we say that? There are huge financial implications from the violation of one of these regulations. We all know that the clauses, or I hope we know at this point that the clauses must be flowed down, but they also should be flowed down in full. There shouldn't be just a reference or a checkbox. The entire clause must be flowed down. And you must have any wage determination in the prime contract, also in the subcontract. And that's critical because if you don't have those things, then the prime may not have adequately flowed down what they need to flow down to the subcontractor, which takes the subcontractor completely off the hook, basically. And you don't want to get into a situation where you're fighting with your subcontractor because DOL has approached you, the prime, and has said, oh, by the way, your subcontractor isn't following the Service Contract Act, for example. It's not in their contract, so you're on the hook, prime contractor, because you promised that you would comply. So you need to make sure that all of that is flowed down to your subcontractor so that you have some leverage. One, you want to be able to tell DOL that you did everything right. And two, because you want to be able to go after that subcontractor for any funds that they're maybe not paying their employees. You also have to be careful with labor classification selections. What do I mean by that? So in the Davis-Bacon Act and the Service Contract Act, we have labor classifications where we're classifying employees in certain job titles. And prime contractors have a tendency sometimes to tell subcontractors what they think those classifications should be. When you do that, you're taking on a certain amount of risk that if DOL says that's the wrong classification, that the subcontractor says, I'm not responsible for that. You told me to pay that certain classification. The way this generally works is that the contractor doing the work, performing the work, decides the appropriate classification. And if they classify wrong, as long as you have everything flowed down, you're insulating yourself from some of that liability. So you want to be, that doesn't necessarily mean you need to be completely standoffish when you're discussing which labor classification should apply. There are lots of situations where you should be working together to resolve those things, but I would caution you against making definitive classification determinations that would possibly bring, liability looking back towards you. You also have to be cognizant of investigations by DOL, because DOL sometimes will deal with a subcontractor or a prime contractor just by themselves, but a lot of times when they start looking back at the prime contractor, there is a cost to that, and it can be a significant cost to get through a Department of Labor investigation. You might have attorney's fees, you have employee time, there might end up being, back wages due. If the subcontractor refuses to pay any of those wages due, DOL is not going to waste their time with the subcontractor. They're going to say, prime, you have to pay. And the question is, do you have what you need in that subcontract to make sure you can enforce that obligation against the subcontractor? Do you have the right indemnification provisions? Are the indemnification provisions broad enough? Have we thought about what kind of information we can get from a subcontractor in order to determine whether there is a concern about labor law compliance? And all of those things you need to think about as you're drafting your subcontract language. Investigations. I wanted to talk about investigations just briefly because these are questions we get a lot. Take, for example, a subcontractor employee comes to the subcontractor and complains that they're being sexually harassed. Who's sexually harassing you? It's my government contact. Well, the subcontractor has an obligation at that point in time per, labor and employment law, per EEO law, to investigate that complaint of sexual harassment. And it's really important that you have a good policy and that you're following that policy. But that investigation is often limited by that subcontractor's ability to contact prime employees and talk with government personnel. And the prime has some of the same challenges with its employees in the government. But a lot of times the questions I get are, as a prime contractor, what are my obligations to the sub? How much do I have to open up my employees to the investigation of the subcontractor? How much information do I need to share with them? The reality is that what happens most of the time is that nobody shares information. The employee ends up getting angry and sometimes will sue everyone and a bag of chips on top of it. So you want to make sure that you've thought about, okay, if we get into these situations with the subcontractor where there's an employee complaint, are we willing to share information? What kind of information are we willing to share? Sometimes it can be as simple as, we, the prime, will complete as much of an investigation as we can complete and we'll share our findings with you. But we're not necessarily going to let our subcontractor's HR department interview our employees. It comes up a lot these days. So it's important that you're thinking about how are we going to handle that from a relationship level so we don't sour part of our relationship trying to get through this sticky situation. Fair pay, safe workplaces. Hopefully some of you have heard about this already. If you haven't, it was an executive order that came out a couple years ago. There's a proposed rule pending right now. We expect the final rule to be out sometime this summer, hopefully, maybe early fall. But basically it says that if you have a government contract over $500,000, you have to disclose any violation of 14 different federal labor and employment laws. So basically any law that you can think of that implicates labor and employment, if you have a violation, and by violation I don't mean necessarily a court judgment, but it could just be a determination from an investigatory agency. And again, I could probably talk about just this for an hour and a half. So, and we do have some information posted on it on our website. So if you want to know more about this particular executive order, please feel free to go look at the materials that we have. But as it applies to subcontractors, it's a little bit scary because there's a 3-year look back period. So we've got to disclose everything 3 years looking back. And prime contractors are responsible for their subcontractors. So what does that exactly mean? First, I want to show you the list. You don't have to commit these to memory, but I wanted to give you a list of the 14 different labor laws. So it's a lot of stuff is my point here. But essentially the way the rules read right now, the prime contractor has to evaluate the responsibility of the subcontractor. So you, the prime contractor, have to stand in the shoes of the sub. You have to get a lot of information. You have to ask them about this information that they have on any violation that they might have of these 14 different labor laws. And before you issue a subcontract to them, you have to determine whether they are a responsible subcontractor. This is going to be an extremely difficult task. I mean, it's not, there's some guidance that's out by the Department of Labor, but it's a very subjective process. But essentially, you have to think, okay, did this subcontractor engage in some sort of labor violation in the last 3 years that's, willful, they did it on purpose, serious, or pervasive? And there are Department of Labor, again, Department of Labor regulations that give us some insight into what that is. But by way of example, the Department of Labor says a serious violation is a determination of back wages of over $10,000. $10,000 in back wages really doesn't seem like that much when we're talking about maybe, let's say, an overtime violation for 5 or 6 employees. You can rack up a $10,000 bill pretty quickly. All of a sudden you have a serious violation. But essentially at this point in time, the prime is going to have to make that evaluation. There is an alternative proposal on the table to have Department of Labor make those determinations in advance. My guess is that that will not become a part of the final rule. Hopefully I'm wrong, but the Congress just denied the Department of Labor funds to enforce these types of provisions. So I'm guessing that the Department of Labor is not going to take on that extra responsibility. So what's the practical implications of having to make these determinations before you issue a subcontract? Well, you're going to need to gather a lot of information from subcontractors that subcontractors are going to be nervous about giving you. They're going to want some confidence that you're not going to share this information with third parties and that you're not going to use that information against them if, say, 5 years down the road you're competing with each other for a prime contract. They don't want you to say, well, I know subcontractor that you have all these problems and I'm going to try to sabotage your bid for this contract. There's a lot of concern out there about how the information that's shared between primes and subs are going to be used down the road. And you're just going to need to pay attention to this. So pay attention to when the final rules are issued, when it goes into effect, and think about how your subcontracts may need to be modified or amended in order to make sure that that the prime can, 1, comply, but 2, that there's enough safeguards to make everyone feel comfortable sharing this type of sensitive information. Indemnification provisions are critical in subcontracts, and both parties have a vested interest in scrutinizing the language of those indemnification provisions very carefully. Sometimes indemnification provisions that are very specific to certain parts of the subcontract they kind of cut out the language about labor and employment stuff. So you want to make sure that, especially if you're the prime, that your indemnification provision is broad enough to cover the types of things we've been talking about today. For example, if there's a Service Contract Act violation and DOL comes after you, you want to make sure that things like your attorney's fees and costs are all captured in that indemnification provision. Make sure again that you look at the language of the clause closely. Subcontractors may look at an indemnification provision and say, whoa, that is way too broad. You're basically saying you can go after me for any third-party claim, et cetera, et cetera. It's really critical that you look at the actual language and how broad it is and think about how broad do I need this in order to protect myself, but not, encapsulating way too much information. You also have to understand that there are inherent limitations in any contract clause, and there are inherent limitations in an indemnification provision. So, for example, your responsibilities as a prime contractor or subcontractor may go, above and beyond what an indemnification provision can protect you from. For example, if you have a Department of Labor investigation, you may have to pay those wages, those back wages that were not paid to employees well before you're going to get any relief from a subcontractor under a subcontract agreement, just because of the timing of how you're working things out. So it's important that you share those concerns up front and you try to work with the subcontractor, the prime, to get the money part figured out as quickly as possible. But keep in mind, DOL is going to want those back wages paid fairly quickly, and your dispute, hopefully, or issue may not be able to be resolved in that amount of time. And that's sometimes where we see a lot of tension rise between two parties when things aren't happening fast enough to keep up with the demands on the investigation. So that was my very quick treatise on subcontracts and labor and employment. Again, I'm sure there's a lot more that we could share, but I want to make sure that you guys have a lot of time to discuss your subcontracting plans.
Thanks, Nichole. So when we were talking about presenting this information today on how to subcontract smart, one thing that we've seen pop up quite a bit lately is subcontracting plans and prime contractor obligations, but also if you're in the role of a small business subcontractor, you have certain rights and obligations under the subcontracting plan clauses as well. So it's important, we think, for all parties to subcontracts, and whether or not you're in the prime contracting position or subcontracting position, to really understand your obligations under these clauses. So as I said right before, it applies to both primes and subcontractors because a subcontracting plan is a material requirement of your prime contract. So if a prime contractor ends up not complying with their subcontracting plan obligations, this can be considered a material breach of the prime contract. So it's important to know what you are getting into and negotiate those obligations up front. Essentially, subcontracting plan obligations are meant to promote the government's objective to maximize small business participation in all federal procurements. And the outlines of the plan obligations are generally outlined in FAR subpart 19.7, but the two main clauses that you need to be aware of are FAR 52-219-8, which is the utilization of small business concerns, and then the actual subcontracting plan requirement itself, which is FAR 52-219-9. 52-219-8, utilization of small business concerns, applies to all federal contracts across the board, including small business set-aside contracts and other socioeconomic set-aside contracts. So no matter if you're a large or small business, you have the obligation to quote-unquote utilize small business concerns to the greatest extent possible when you're performing your prime contracts. FAR 52-219-9, the Small Business Subcontracting Plan Clause, is the actual subcontracting plan obligation clause, and that only applies if you are a large business prime contractor. But then, if that clause is incorporated into your prime contract, you then have the obligation to flow it down into all of your subcontracts. The clause itself actually does not apply to small business contractors themselves. And then the SBA includes their rules for small business subcontracting at 13 CFR section 125.3. So that's where we'll see a lot of the SBA specific rules and regulations regarding small business subcontracting. And it's interesting because your subcontracting plan obligations, as I said before, are a material requirement under your prime contract. So essentially, when you negotiate these goals with the agency, this is a contractual obligation to the agency. However, it's SBA as a separate agency, another federal agency, who's really doing the enforcement aspects of your subcontracting plan. So it's an interesting, I think sometimes you see a tension between your prime contracting agency. Let's say you have a contract with like DHS or something, and DHS, you're negotiating those goals with your contracting of your each goal for your specific socioeconomic subcontracting spending with your DHS contracting officer. But if you get audited down the road, it's SBA that's going to come in and say, okay, well, did you meet those goals? Did you make good faith efforts to comply with those goals? And then SBA will make a recommendation to DHS, the contracting officer, and say, okay, make your contractor essentially fix these problems. So it's a weird tension and dichotomy. So there's several different types of plans that you can enter into when you get the initial contract. An individual plan is specific to this particular prime contract that you have. So if you have, one DHS contract and you negotiate with the contracting officer and you say, okay, I'm going to do, 2% for hub zone companies, 2% of my small business spending will be for SDVOSBs, 3% AAs, etc. So you're entering into those specific goals for that one particular contract, and that's called an individual contracting plan. There's also master contracting plans, which the terms and conditions of your subcontracting plan will apply to all your federal contracts across the board, but then within that master plan, you have to still negotiate individual subcontracting spending goals for each particular contract. It's just that your terms and conditions, you don't have to redo your terms and conditions for each prime contract that you enter into. The third one listed here is sometimes the one I think that gives people trouble and that's interesting. Commercial subcontracting plans are if you have a prime contract where you're providing commercial items to the government. You can enter into one plan with one agency, and that plan will apply across the board for all of your commercial item contracts. So you don't have to enter into specific plans with each agency for each individual prime contract that you hold. This one commercial plan will cover all of your federal government subcontracting plan obligations. And then the fourth one here is something interesting that we've seen recently. It's the DoD test program for comprehensive small business subcontracting plan. And it's a test, I think it's very targeted and specific to individual contractors that DoD has identified. So it's not common, but we just thought we would include it there. So I'm going to very quickly run, or maybe not so quickly, but this is, your compliance effort with your subcontracting requirements. This is where really like the meat of what your obligations are come into play, and you should know these issues fairly well while you're negotiating the subcontract, and then also while you're performing the contract and gathering the data. So first you have your reporting obligations under FAR 52-219-9. And this is the type of information that you submit through the electronic subcontracting reporting system, which is known as ESRS. For individual subcontracting plans, you have to submit information on a biannual basis, usually April 1st and October 30th. And you use the standard form 294 to fill in your goals. For commercial subcontracting plans, you just submit the information once on an annual basis, October 30th, utilizing standard form 295. When you're reporting, you need to make sure that you're counting only small businesses that meet the subset definitions and all the categories that are applicable to your plan. Like I was saying before, like hub zone, you only want, if you're reporting your hub zone small business spending dollars, you want to make sure that you're only utilizing hub zone companies. You want to make sure that you're only counting subcontracts that are applicable. You want to make sure that you revise your goal dollars and goal percentages during all the option periods for the contract. And you want to make sure that there's no task order, specific task order reporting for this. Sorry. I think that notification requirements for non-use of small businesses. This is something important, I believe, for specifically for small businesses. It's almost kind of like know your rights as a small business that a prime contractor has used and proposed to the government, and saying that they will use you during contract performance. That you need to know that the prime contractor can't simply say, okay, we're planning on using hub zone company X during contract performance, get the credit for that in its proposal evaluation, and then get the contract award, and then walk away from you. So when a prime contractor does not utilize the small business subcontractor when it's used in the preparation of its proposal, it has the obligation to report that to the prime contracting officer. They also need to tell the kind of tattle on themselves when they reduce payments to the small business subcontractor, or when the payments to the small business subcontractor are 90 days or more past due. And primes and other subcontractors can also file size status protests on small businesses that the prime has proposed to utilize for small business credit, and for whatever reason there's an issue and they think that the small business might not actually be small. These are like the tattle on yourself provisions. Compliance efforts should also be ramped up when it comes to vendor identification. You want to make sure that you're collecting the self-certifications from each specific vendor that you're using to meet your small business subcontracting plan obligations. And small business subcontractors, this is why you might have, when you're a subcontractor for a large business, they give you a self-certification form and they want to see, you know, what are your number of your employees, what's your average annual revenues, what Naiks Codes do you have, what are you representing, are you a SDVOSB, VOSB, 8A, minority owned, you know, these are the reasons why they're asking you for that information. They have an obligation to collect that information and keep it on file. In case they get audited, they need to be able to substantiate the numbers and the figures that they've reported on their subcontracting plan goals. And these representations have all the same full force and effect that normal small business representations have. So small businesses, you need to know, even though this is just being used for your subcontracting, your prime subcontracting plans, these are real small business representations, and you could potentially be on the hook for misrepresentations. One thing we might mention here too is that nonprofit organizations should not be classified as small businesses for purposes of small business credit. And if the prime contractor doesn't have the self-certification in its files, it should technically not be counting that that subcontracting spending towards its goals. Another compliance effort that you need to be thinking about is diversity. You want to be making sure that you are utilizing all types of subcontractors, minority, women-owned, 8A, hub zone, SDVOSB. There are multiple resources available through SBA and alliances out there, such as, you know, the the one with the WeBank. I was blanking for a second. WeBank, or all those other type of organization. If you're having trouble identifying specific small business contractors, you can use these types of organizations to help you find them and do matchmaking efforts. So if you are being audited, if you do get to the point where you have a subcontracting plan and you have, for SBA has audited you, they want to make sure that you're taking good faith efforts to make sure that you're meeting your subcontracting plan obligations. So make sure that you've compartmentalized your efforts within your organization, that you're performing the proper market research to identify small businesses that you could use on your contract performance, that you're doing networking events, that you're soliciting RFPs to small businesses, and that you have the proper management support from your CEOs and all the and your organizational leadership, that this is a priority and that you are prioritizing small business participation in your contract performance. And also another best practice, you should also implement policies and procedures with regard to your subcontracting plan. Who's going to be responsible for what? You should assign a small business liaison officer to monitor and administer the program. Develop standard operating procedures whenever you have a supplier, a supply order or a vendor order. If you're soliciting new vendors, new suppliers, if you've got a commercial plan, you want to make sure that you're collecting all the self-certification forms and that they're being properly filled out, and that you're training your contract personnel to identify small businesses and know that this is a priority of the company. So why should you be focusing on compliance? That was a lot of information all at once, but why do you need to be focusing on your compliance efforts if you have a small business subcontracting plan? This is an area where we've seen a lot of developments on Capitol Hill lately. The current climate is definitely focused on more oversight and enforcement of subcontracting plans. For example, the 2016 NDAA, it includes several provisions to improve monitoring of existing plan requirements, including an agency scorecard program, and put actual requirements on the GAO to issue several reports within the next year on agency subcontracting plan compliance. There's also been an effort by the House Small Business Committee they had a hearing recently to address whether small business subcontracting opportunities are quote-unquote real. And they've had panels advocating for stricter accountability for subcontracting plan goals. So this is something we're seeing a lot of activity and focused on. Also, the number of SBA audits are up, and we've definitely seen that in this office. With companies coming to us and saying, we've got this notice and the SBA is coming in to audit this, and we have a plan, but to be honest, our files aren't great. And we're like, oh gosh, so like you need to, and then that gets the whole ball rolling. So if you are a planner, and you have these subcontracting plan obligations already, it might be worthwhile for you to see if you're ticking, revisit the issue, see if you're ticking all the boxes and you're meeting your obligations. Because the stakes are high for non-compliance. You can potentially be found in breach of contract. You can get an adverse past performance assessment with regard to your contract performance. That's one of the questions the CEO is supposed to fill out when they fill out the evaluation of your performance on the contract, whether or not you hit your subcontracting plan goals. It's also sometimes we've seen it as an evaluation factor in RFPs, whether or not you have met your goals in the past. And then there's also the threat of liquidated damages, which is scary. But I do have to say we've rarely ever seen this actually go into be actually assessed. Essentially, if the contracting officer does have, it's sort of like, the stick part of the carrot and stick, they can assess liquidated damages if they found that you haven't been meeting your goals. However, that's only after SBA has come in and done an audit of your plan, and really you have to have made absolutely zero good faith efforts to comply with your obligations before liquidated damages can be assessed. But the threat is out there, so that's why you should be taking this seriously. So some best practices that you should do, think about when you're formulating your subcontracting plans with the agencies. Establish realistic goals right up front. That's important. If you know, it's easy to say, okay, I know that government-wide, the goals for small business spending are 23%, and 5% of that is 8A, 5% hub zone, et cetera, et cetera. That doesn't necessarily mean that you need to be putting those goals into your plans that you negotiate with the agency. If you've done market research and you know that only large businesses are available to subcontract a particular portion of the work that needs to be performed, you can try to negotiate up front to exclude that. Or you know that there's not a number of hub zone firms out there that can do the type of work for your particular contract, well then, instead of saying I want to do 3% hub zone, say 1%. Get the numbers down, because it's a negotiation process when you're setting these goals. You want to know your exclusions from the subcontracting base. So it's important to say that that your goals are pinged to your total subcontracting dollars. You want to be wary of goals that are based on the total contract value. You want to make sure that your goals are actually tied to your subcontracting base and the subcontracting spending that you're actually planning to do, not the total contract value. You want to make sure that you know what you can exclude from the subcontracting base, and this can be found in the SBA's regulation. For example, you can exclude salaries and wages, employee insurance, original equipment manufacturer relationships, utility spending, charitable contributions, bank fees, things like these items can be excluded from the base. So know what you can exclude. You also want to make sure that you thoroughly vet your small business vendors. And like I said before, you want to make sure that you collect the current written self-certifications of all small business and socioeconomic participants that you have, that you're counting towards your plan dollars. And also sometimes you want to make sure that you get independent verification of those written self-representations. For example, there's a requirement if a company is saying that they're hub zone, you need to go look up and see whether or not they're hub zone on the SBA's DSBS database. So just make sure what they're representing to you jives with what their representations are in SAM and on DSBS. You also want to make sure that you have a written subcontracting plan manual in place. Your manual should address things like what are the covered supplies and services that you're covering under your subcontracting plan, your program administration and SBLO's responsibilities, who's in charge of the plan, who's running the plan for the company, that there's periodic check-ins and evaluation on how you're doing with your program performance, record-keeping procedures, your maintenance of your vendors list, that you're properly keeping up with your vendor self-certifications, that you're including all the correct flow downs in your subcontracts to these particular vendors, that you're doing your reporting on a regular and annual basis, that your CEO and senior leadership are approving and actively involved in your subcontracting plan decisions, and that you're properly training your employees. So like I said before, this is an area where we've seen SBA really step up their monitoring and interest. I mean, we've seen there's a lot of activity on Capitol Hill about this, and SBA, I think, has received some marching orders here saying we need to start monitoring this on a more active basis, that this is a real material requirement of prime contracts, and we need to make sure that prime contractors are living up to their obligations. So Audits are performed by regional SBA offices, either by the PCRs, the Procurement Center Representatives, or the CMRs, Commercial Market Representatives. And to a certain degree, contracting agencies or DCMA may also be involved in the audit process. And the audits can be either fulsome or targeted. For example, SBA can do a full subcontracting program compliance review where it looks at your total subcontracting program and really gets their, their hands dirty and rolls up their sleeves and starts digging through everything. They can do a specific performance review on a contract-by-contract basis. They can also do what's known as SOARs, which is a subcontracting orientation and assistance review, where they physically come to your office and site and go through your documents and make sure that you're maintaining the correct self-certifications, written self-certifications, that you have a compliance file, that you have a vendor list that you reference, that you have written policies and procedures. And then they can also do follow-up reviews if they've done a review of your subcontracting plan compliance and there were a few follow-up questions and they made recommendations. They can come back, a year later and say, okay, did you implement our recommendations? So typically, SBA, when these reviews get started, SBA will send you a letter and they say, okay, we're coming. And you get all your information ready. We're sending somebody out there. And usually the person will come for 1 or 2 days and they will coordinate with your company's SBLO. And they'll want to see a lot of information up front and make sure that you're hitting your targets and that you're maintaining the proper records and compliance information. So you'll have to submit all subcontracts that you've made to small businesses within the past year, all subcontracts to large businesses over $150,000 within the last year, and all blanket purchase agreements entered into within the last year. And then SBA will typically select samples from each list, about 20 to 30 from the list of the small business subcontracts, and then they'll drill down on the samples during their visit to determine if you have the necessary supporting documentation to back up what you've reported. As part of this too, you must complete the SBA Compliance Review Checklist, where you have to answer certain questions about whether you've been hitting your goals, historical trends, your outreach efforts. They'll want to see your letter support from your CEO, policies and procedures, etc. So you want to be thorough when you're giving this information to them. Essentially, they're looking to see, are you making good faith efforts to comply with your plan's requirements? And then you get a grade. There's 1 of 4 grades that they can do, either outstanding or acceptable. On the other end of that is marginal and unacceptable. So obviously marginal is better than unacceptable, but both of those grades will require the contractor to implement what's known as a corrective action plan. And they have to submit that corrective action plan to both SBA and the agency, and failure to follow up and implement your goals for the corrective action plan can result in penalties and liquidated damages assessments. And then this is when the follow-up visits start. If you've implemented your corrective action plan, SBA is going to make sure that you've actually, done what you said you're going to do. So that was pretty much a quick overview of subcontracting plan compliance and issues. I just wanted to make sure we touched on that because that's becoming a big issue with regard to subcontracts and rights and obligations between the prime and the sub. But I also wanted to alert you to a few regulatory updates. This is a proposed rule that we saw last year, or end of 2014, which has been long promised, which is a change to the way that SBA is going to formulate the limitations on subcontracting rule. So we saw it come out in 2014, December 2014, supposedly promised this year. So for subcontracting plans, the new obligations are going to be now that before Prime identifies the small business name in its proposal or subcontracted plan, the prime has the obligation, the affirmative obligation, to notify the small business in writing. And there's going to be penalties associated for primes that do not provide the written corrective action plan or not demonstrate good faith efforts to comply. So, as I said before, this is, an area where Congress and SBA are really focusing their efforts on making sure that prime contractors are complying with their obligations. We're also seeing a new lower tier subcontracting rule that came out last year, which implements directives that were found in the 2014 NDAA. And this is going to be sort of a game changer for subcontracting plan compliance in that for individual subcontracting plans, you can now count small business spending on any tier, any subcontracting tier on the contract, not just the first tier subcontractors, but second tier subcontractors, third tier subcontractors. So there's going to be an issue on how this really is going to be able to be counted, because SBA has also put in something within this regulation that says they want to make sure that there's no double counting of the subcontracting dollars at these lower tiers. They haven't really clarified how that's going to happen, because it seems to us anyway that both primes and subs can count those lower tier spending. So it does also include some increased obligations with regard to primes' obligations to monitor their subs and enforce their subcontracting plan requirements. And then we've also seen a change to FAR 19.7 and 52.219-9. And this will require the subcontracting plan to list Naiks codes for each subcontract. So this is something when you're entering into your subcontract, you're going to need to include a Naiks code for that subcontract. And it might not be the Naiks code that was assigned to the prime contract. Prime contractors have the obligation to identify what Naiks code best suits the work to be performed on the subcontract and to assign that specific Naiks code to that subcontract. So it requires an extra step of effort on the prime contractor's part. So these obligations are going to be a little bit more complicated than the current obligations, and it's just something to keep on your radar. And then additional changes are primes cannot prohibit subcontractors from discussing payment or utilization matters directly with the contracting officer. So that's again, one of those subcontractors, you need to know your rights. You have the right to go to the CO and talk about payment issues. And again, primes must notify unsuccessful subcontractor offers in writing that they're not going to be utilized, and it codifies the failure to comply with good faith with subcontracting plans as being a material breach of contract, and that this can be considered in past performance evaluation, which we already talked about before. So that takes me to the end of
I think we have a couple of minutes for questions. So we'll start just going down the list of questions in the order they came in, I suppose. And again, if you have other questions, please feel free to write them in now or just shoot us an email. We'd be happy to answer those questions for you. The first question we got involved non-solicitation clauses. And a very common piece of a non-solicitation clause, as this questioner pointed out, is that if somebody applies to applies for a vacancy announcement, meaning your employee just went out on their own, there was no solicitation per se, you can call. Then that's a backdoor, and you're absolutely right. It is a backdoor because what we see commonly is either the prime or the sub, depending on who it's being applied against, will call and say, well, how do I know that person really applied? Because I've heard whispers from somebody on a contract that from another employee on the contract that the project manager or some other employee is going around saying, hey, you'd be great for this job, it was just posted, apply for it. And is that really solicitation? The second part of the kind of question was, what do we do about this? Because the response you get when you question that language is, well, it's required by law. It affects employees' rights. I haven't seen particularly that type of language is required by law. Again, these contracts are state law specific, so you always have to check your state law. But in general, these clauses are enforceable in most states, and even if you don't have that language. What could be the case is that they don't want to necessarily limit their ability to consider a candidate that applies of their own volition. But the reality is that you have a lot of goodwill stored in those employees, whether they apply on their own for a prime or for a position with the other contractor or not. And if you have the the leverage in that negotiation to say, no, we don't want that caveat because of all the problems it can cause, that's totally, that's your right to pose that as an issue. Where employee rights and the legal obligations really come in, and there are more restrictions, is on the actual employment agreement piece. And one way, even if you don't have the leverage to negotiate that language out of your subcontract, is to look to the non-solicitation, non-compete provision in the employment agreement, with your agreement with that employee. And you can certainly, in most states, unless you're in California, for example, you can draft your non-compete agreement to prohibit the employee from going out and doing that. So you might not be able to, cross that hurdle in your subcontract, but it may be something you want to consider a non-compete with the employee. So you really have to look at both the employee-employer side of this and the contractor-to-contractor side of it and figure out where you have the leverage to kind of protect your assets. But you certainly have, we call it a protectable interest in your goodwill and trade secrets to try to prevent some of that exchange if it's in your interest to do so.
I think we have one more question that we wanted to cover, and this was just a quick one. We got a question whether small businesses or 8A prime contractors are required to implement subcontracting plans or do annual reporting. And the answer to that is no. No. If you're a small business or some other type of socioeconomic small business, such as an 8A, you do not have to enter into a subcontracting plan. This is only for large businesses, large business prime contractors, and then those requirements get flowed down to their large business subcontractors. Great. So you do have an obligation to adhere to 52219-8, which is utilization of small business concerns, and that applies across the spectrum to all contractors, that you have that affirmative requirement to identify and utilize as many small businesses as possible in your subcontracting efforts. But no, small businesses do not need to implement subcontracting plans. That's important.
Well, we want to thank everyone for joining us today. We know that your time is valuable, and we appreciate that you're willing to spend some of that time with us through the afternoon. Again, please feel free to follow up with us and reference any of the material we have on our website or on our YouTube channels. We have a wealth of information and webinars that you can reference there. And otherwise, we look forward to working with you all in the future. Have a great afternoon.